Navigating probate court in Kansas requires careful attention to several key steps. First, if the decedent had a will, it must be submitted to the local probate court in the county where they lived. The court will then appoint an executor to oversee the estate. If there's no will, the court appoints an administrator under Kansas intestacy laws. The executor's job is to collect assets, pay debts, and distribute what's left to beneficiaries. One of the first challenges is identifying and valuing the decedent's assets. Assets subject to probate, such as property and bank accounts solely in the decedent's name, must be located and assessed. Overcoming this challenge requires diligence in gathering financial records and property titles. It's also important to settle any outstanding debts with creditors promptly to avoid legal delays. Common challenges include disputes among beneficiaries or unclear instructions in the will. To avoid these issues, open communication with all parties is essential, and legal advice can help mediate conflicts before they escalate. The necessary documents for probate in Kansas include the death certificate, the will if available, a list of assets and liabilities, and a petition for probate. Executors will also need to file a final accounting with the court. While probate can be complex, by following these steps and working with legal professionals, you can ensure a smoother process and respect the wishes of the decedent.